you had previously made reference to and filed a motion for a speedy trial in your cases, and I'm prepared to give you a trial tomorrow on the on the failure to appear case.
Yeah, I'll be ready for that. I do have a request of the courts, though. I still have some video evidence at the jail.
Video evidence of what?
Of the discovery that was in my discovery packet at the jail. And they're under the impression that I don't have any more court. When I asked to view it, they're telling me no.
Well, they'll be notified that you've got trials coming up. The trial tomorrow is a failure to appear, which shouldn't have any video evidence that would.
No, that's understandable, Your Honor. I don't understand where they're getting their information that I'm through with courts, and it's hindering me to be prepared when I come to court.
But we'll make sure that the bailiffs relay to the jail and that the clerk relays to the jail. You do have other cases pending.
Are we going to make a ruling on the rest of the motions today, Your Honor?
I'm going to make a ruling on your motions today after we hear from the state.
Okay.
Judge, on the motion to withdraw guilty plea, I searched for case law that was on point where a plea was entered in front of the jury, and there's not a lot out there. I did not find a single case with those specific facts. I did find, and of course it is my duty to tell the court any case law that I find that is against my interest. There is substantial case law that talks about how the defendant must be notified of all his rights in a waiver and waive them knowingly and voluntarily and say that on the record. I don't think we did a rights waiver in this case, and so I leave it to the court's discretion if that would be reason for the withdrawal of the guilty plea. Based on how you rule on that, with the sentencing, normally the defendant would not need to file a motion for new trial until after the sentencing. So I don't know that he needs transcripts before we do the sentencing, only before he would file a motion for a new trial. So the state would be ready for that when the court chooses. And then you have handled the other two motions on your own, unless you want me to address either of those other two.
That's all right. Just wanted to give you an opportunity if you want to be heard.
Judge.
All right. On the motion to withdraw the guilty plea, there isn't, as General Bryson points out, any clear direct evidence case law on the point. The defendant was representing himself with elbow counsel, and for that reason, he was given some specific advice. Now, he argues that the advice given to him by his elbow counsel was, in fact, not the appropriate advice, or it was not sufficient because he did not realize that he could not appeal a guilty plea. Well, he can appeal the sentence imposed, but he cannot appeal the finding that he's guilty of driving on a revoked license. But